think we'll go ahead and get started with some of the intro stuff. I know that, I understand that there was coffee recently delivered, and so I think the attendance will probably pick up here as the coffee line goes through. So, my name is Jeff O'Brien. I'm an attorney with Loman Abdo. We're based in Minneapolis because I have an office in Hudson, Wisconsin. I've been practicing now for 15 years in November, doing transactional law business, real estate transactions. And close to 6 years ago, started working with craft breweries. And in that time, I think I've done just about everything you could possibly do with a brewery in terms of a legal issue. And the topic we're going to talk specifically about today is raising money, raising investment capital, and doing it legally. I'm cognizant of the fact that it's 8 o'clock in the morning on a Friday, and I know that if you've been, having been out to the Brewers Association Craft Brewers Conference, I know what everybody's feeling like at 8 o'clock in the morning. So I'll try to keep this, I'm going to try to blend in some practical stuff. I'm not going to try to inundate you with, overly legal, technical stuff because, coffee can only do so much. But we're going to talk about a lot of stuff. We're going to talk specifically about securities law, and there's a lot of stuff. It's kind of funny. After 80 years of being the same, there's finally changes in these laws, and we'll talk about the specific provisions. But a lot of it is motivated by a recognition that was a lot of the regulations that have been in place for decades that were stifling small businesses' ability to find money. And that's what's motivated the changes, everything from solicitation rules to crowdfunding. States are changing their exemptions, and so it's a hot area right now. So what I'm going to try to do is talk a little bit about those legal issues in terms of kind of the specific provisions, but we're also going to talk about where this whole financing thing piece fits on the spectrum in terms of if you're planning a brewery, what do you have to think about, what other sources of funds are out there before you go to investors or equity capital. So that's what we're going to talk about. If anybody has any questions along the way, just put your hand up, and if we get to a spot where we can break here, I'll try to answer some questions. I like these smaller group discussions because we can get those questions answered. And I mean, for you guys, it's nice because you can ask me questions and not get billed for it. So everybody likes to always ask the lawyer questions when they're not on the call. So, okay, let's start by talking about where does financing fit in the order of steps in starting a brewery. Now, when I say financing, I mean more than just equity investment. Okay, financing means a lot of things. We'll talk about that in a minute. But in terms of overall, when do you start going out and trying to find money for your brewery? This is what I tell my clients, and this has been my experience in working with breweries in terms of where it fits. Obviously, you start with a business plan. Whether you're talking to banks or investors, you got to have your business plan. You got to know what you're going to do. You got to know what your angle is going to be in terms of getting into the industry. You have to have a plan. You have to have that in place. So you really shouldn't be out at market talking to anybody about your brewery until you have that done. That is priority number one. The second piece you want to put in place, you want to get your entity formed. Because any kind of offering, any kind of loan is going to come through that entity. And whether it be a bank, they're going to ask to see your articles of organization or articles of incorporation. They're going to want to see your bylaws. They're going to want to see buy-sell agreements. Investors, you have to disclose those same things. So you want to have that piece in place. The other thing you want to have in place, you should be filing a trademark for your brewery name. Because the worst thing that could possibly happen it's not so much a legal issue, but it's embarrassing if you went out, said I'm XYZ Brewing, and put together your business plan, form your entity, put together an offering document, we hit the streets with it, and then you find out that there's XYZ Brewing in Colorado that has a trademark on that name, and now you have to go back and tell people that you just asked to write you a check. Oh, by the way, we're now ABC Brewing. So you don't want to have that discussion. It's a practical, issue that you don't want to do that. You want to get the name clear. You want to have a location at least identified. You can go to market without having a lease in place, or if you're gonna buy without having it closed. But if you're gonna do that, you should at least have a letter of intent for the lease, or and be reasonably confident that you're gonna close it, and or have a purchase agreement in place for the brewery. So that's the other piece you want to have kind of in place. And then at the same time you're identifying that location, that's when you have the financing discussions. You're talking with banks, you're talking with local governments, possibly about incentives, and you're then putting together your offering. And then after all that, once you get funded, then you do your purchasing, you do your equipment, you do the build out, and you have your licensing to TTB in the state. That's been my experience as to how this all plays out. So let's talk about sources of funds for your brewery. And if you see this little spectrum here that I've put together, that's kind of my order of, I put equity investors at the end of the chain. I'll explain in a minute why. Obviously, if you have your own funds, you use them. It's the easiest way because you don't have to ask anybody anything. You don't have to disclose anything. You just put your money in, you buy stuff, and you start your brewery. But not everybody has it. I mean, we got a little Mr. Monopoly guy up there. Not everybody is, is Mr. Moneybags. So then the next step, I always tell clients, a lot of folks come to me and they say, we need, $1.5 million. And they're starting to talk about what they're going to offer investors to give them $1.5 million. And I tell them, wait a minute, have you talked to any banks? No. That's the first step. You want to talk to the banks first, because with debt financing, as long as you're staying within your loan covenants and staying current on your payments, they're going to leave you alone to operate your business according to your business plan, okay? And so that's the least intrusive amount of money, the least intrusive source of money that you can have. So I always tell my clients, go talk to the banks first. There's SBA programs, and that you can finance your equipment. If you're buying the property, you can finance the real estate too. They're your first conversation you have after you have that business plan together and your entity. Go talk to them. The next step is gap financing. I'll talk about that in a minute. We'll talk about rewards. When you talk about crowdfunding, there's been rewards crowdfunding and equity crowdfunding. Rewards crowdfunding is Kickstarter. I'll talk about that in a minute. And then you get to this, talking about putting together an offering of equity to investors and what the terms of that will be. So that's kind of what I use as my kind of spectrum here in terms of where this all falls in. So let's talk about the other sources of financing. I already talked about bank financing, like I said. There's SBA programs. There's a Section 7A loan. There is a 504 loan. 504 loan is typically used when you're buying, you're buying the building as well. Like I said, talk to the banks before you talk to investors, because you're going to figure out it's the gap between what a bank will give you, what you can get from gap financing, what you may be doing through a Kickstarter offering. It's that gap that gets you to what your amount of your private offering is going to be to investors. And it's significant because, as we'll talk towards the end, there's a lot of different mechanisms, a lot of different incentives you can offer in an equity offering to investors. And part of that depends on how much you're asking for. And it also depends as to how much you have secured, or how much you're bringing to the table. And you want to, you don't want to, you're doing this business because you want to make this your career. You're obviously leaving some other type of day job to do this. You don't want to end up going back and working for somebody else, like which you would be if you give away too much to investors. So, go back in just a second. Okay, so let me talk about gap financing just a second. There's a lot of cities that have economic development departments that have programs, loan programs. If any of you are familiar with the brewery scene in the Twin Cities, the reason Northeast Minneapolis has become the hot spot for breweries And the reason it happened is it started with the fact that the city offers economic incentives to locate in that area. That's why the original crop of breweries located in northeast Minneapolis, because you can get $25,000 to $75,000 depending on where you locate through the city. Other cities have economic development authority, and they have their own kind of loan programs or matching funds, and so that it's kind of an untapped source in a lot of cases. So if you're looking for a location, be aware of what cities offer in terms of economic incentives, because again, it reduces the nut that you have to get from investors or what you have to bring to the table. Rewards type stuff, whether it be Kickstarter. I've seen a few breweries that have done, you raise a few $1,000s on Kickstarter by giving away, glasses or T-shirts or things like that. I've done a lot of membership clubs or founders clubs for breweries where you don't get any profits or any share of profits in the enterprise. What you get is stuff. So they might have, like, if you pay X amount, you get a pint, one pint per visit free, or a growler a week free, or you get your name on a brick on the wall, or a T-shirt, or a private party with your friends, or tours, exclusive VIP parties, depending on whatever amount you've contributed. Those are all types of rewards-based crowdfunding. Those usually come, the Kickstarter stuff, sometimes breweries will use that to maybe fund some initial expenses, like, paying an attorney to help you do some of this stuff, or doing some of those kinds of things, or paying a marketing firm to design your logo or something like that. The membership clubs usually come after you've been funded and are part marketing program, and it's kind of gravy on top. So I had a client recently that did a Kickstarter to raise funds for their tap room. It was the last piece they had. They had closed on their building, they had closed on their loan. They used it basically as a marketing tool to get people to be aware of their brewery, and they sold out their Kickstarter campaign. So it's more marketing than it is a source of heavy-duty funds to start the brewery. And now we get to investment capital. So after you've gone through all those different sources, now you're going to start dealing with talking about selling equity in your business. And with that comes worrying about complying with securities laws. Now, why do securities laws exist? Well, as you can see from this news headline, it was the stock market crash in 1929 and Franklin Roosevelt being elected and some laws being passed to curb what people perceived as abuses or people, kind of speculation in the stock market. And that's where this all came about. And these laws we're talking about are 1933 and 1934 when they were enacted. And they stayed pretty much the same for 80 years. This has been the regime. And they are very highly restrictive, as we'll talk about. So we have the three primary sources of law that you have to worry about being compliant with. You have the Securities Act of 1933. You have the Securities Exchange Act of 1934. And you have what are called blue sky laws of each of the 50 states. And the way they interplay, the Securities Act of 1933 governs the registration of securities or provides for certain exemptions from registration. The 1934 Act it regulates the secondary trading of securities, but it also created the Securities and Exchange Commission, the SEC. And it's the SEC that oversees all of the federal securities laws regulations. And then you have state blue sky laws. Every state has some sort of kind of pattern after the federal law. They have the general rules you have to register with them or find an exemption from registration. And you have to, when you're dealing with raising money from investors, when you're dealing with the blue sky laws, you have to be concerned with the laws of each state where you're soliciting investors, okay? Some of those laws require some documents to be filed prior to the first offer of securities. So you have to be cognizant, if you're going to talk to somebody in California, you need to know what exemption applies and how you have to comply with that. Because what these all are, whether it be federal or state, they provide for safe harbors. Okay, if you do this, then your offering is copacetic and legal. So that's kind of how this whole regime plays out. Now, this is a key question. What is a security? I have been doing, as I said, I've been practicing for almost 15 years. I've done a number of securities-related transactions, a lot of them with breweries, some not. And this is always one of the, if I had a list of the top 10 incorrect things that I've heard from clients, one of them would be, oh, I'm not selling securities, I'm selling notes. It's not about what you're selling. It's a lot of it is dealing, they look at what the instrument implies, and then they're also looking at how you're selling it. So the legal definition of a security from the Federal Securities Law, the 33 Act, is any note, stock, evidence of indebtedness, certificate of interest, or participation in any profit-sharing agreement. So there isn't really, if you're going to offer an investor a share of the profits in your brewery, there isn't really a way around securities laws. You have to comply with them. So whether you call it a convertible promissory note or just a promissory note, or whatever you want to call it, at the end of the day, it's a security. It doesn't have to be a stock to be a security. When you're dealing with, you're raising money for a brewery, you're dealing with what's called a private offering or a private placement. Now, like I said, the default under the 1933 Securities Act is that you have to register your offering with the SEC. Now, you've heard of initial public offerings, and that you file documentation with the SEC, and every quarter and every year you have certain reports to file to them about your earnings and things like that. That's the default. But they also have two sections in that act. There's a whole section of exempt securities, and then there are exempt transactions. And it's usually the exempt transactions that you're dealing with, trying to find an exemption. And you also need to find an exemption, like I said, from the blue sky laws, where in each state where an investor resides. So, this is the next key concept. We talked about what's a security. Now we got to talk about accredited investors, and our little monopoly man guy is back there. The general rule is that the more sophisticated and financially well-off the investor is, the less complicated and costly it's going to be to comply with the securities laws. So remember that. And the big issue is whether or not the person you're soliciting is an accredited investor. That's a defined term in the 1933 Act. It's actually in Regulation D, Rule 501. And there's certain qualifications that an accredited investor has. And they're deemed to be sophisticated enough to make investment decisions for themselves, such that you don't have to spend a lot of time reporting things to the SEC and having the SEC, monitoring and regulating your company and having to turn in financial statements on a regular basis, because these folks you're soliciting should understand what you're getting into. Now, there's a lot of different ways to qualify as an accredited investor, but here are the most common ones. One is to be an individual with at least $200,000 in annual income over the last 2 years, or $300,000 jointly with a spouse. Okay, that's one way of meeting the accredited investor standing. The second way is to have a net worth of $1 million or more, not including your primary residence. That was an outgrowth of the real estate market crash a couple years ago. They revised the accredited investor definition and took the home out of the calculation. So it was just $1 million net worth, not including your house. You can also have an entity in which all of the equity owners are accredited investors, or if the entity has at least $5 million in net assets. So you can't take, you know, a group of non-accredited investors and pool them together to get to the $1 million and say it's and form an LLC and have the LLC be deemed accredited. Everybody would have to be accredited unless it has $5 million worth of net assets. And this is very significant as we go forward here talking about these exemptions, because it is, like I said, it's far more expensive to solicit non-accredited investors. Now this is changing with some of these. We'll talk a little bit later about some of the changes with the crowdfunding laws and some of the Jobs Act stuff. And that's what a lot of this stuff is getting at, is for a long time, the non-accredited investors have basically been shut out of investing in small businesses. And it's actually, in my opinion, it's been the growth of the craft brewing industry that's been pushing for these changes, because the folks that most want to invest in a brewery are the folks that have been shut out by the laws. And I think that's what's driven a lot of the, I think that's part of what drove the Jobs Act in 2012, and I think that's part of what has been that certainly fueled Minnesota's crowdfunding legislation this year, is everybody's realizing that we've got this really growing industry and we're cutting off, maybe 90% of the populace from investing in it. So, when we talk about a private offering, it's called a private placement, is what is the term. And the exemption in the Securities Act is under Section 4.2. And the safe harbors, now Section 4.2 exempts transactions, involving the offer of sale of securities, not involving a public offering. So it's so it's private. And there are certain factors that you look at to determine whether or not you're doing a private offering. So you're looking at the qualifications of the offerees. Again, whether or not the investors are sophisticated. Like if the safe harbor, of course, is if you stick to accredited investors, and we'll talk a little bit towards the end about mechanically how you verify that. They're going to be deemed to be sophisticated. They look at the nature of the offering, what level you engage in advertising or promotional activities, the availability and accuracy of information given to offerees and purchasers. When you're doing a private offering, we provide copies of corporate documents. We provide, if we have financials, we provide those, copies of leases, anything relevant. You disclose to your potential investors. The number of offerings that you've engaged in, and the number of purchasers. So you're looking at the size of the group of people that are purchasing from you. The smaller, the better. And if there's an absence of intent to redistribute the shares, meaning a lot of times these are restricted securities. You have to hold them for 2 years. The idea with a private offering for a small business is this is not a stock that's going to be traded on some kind of exchange or traded on a secondary market or moving around hands from person to person. Someone's investing in the business because they want to invest in that business, and they're going to buy and hold it. And that's another factor that factors into whether or not you have a true private offer, not an offering that's not a public offering. So, like I mentioned before, to qualify for to be deemed to be doing an offering, not a public offering, there's a safe harbor in the regulations to the 33 Act, and it's known as Regulation D. And the SEC has provided a clear set of safe harbor rules that an issuer can follow to ensure that they're conducting a valid private placement under Section 4.2. And they're referred to as Rule 504, Rule 505, and Rule 506. And as of last year, I think it was, 506 now has a B and a C. So there's 2 different versions, and that comes out of the Jobs Act, and I'll get to that in a minute. So Rule 504, you can raise up to $1 million from an unlimited number of accredited and non-accredited investors. And then, of course, you have to also find blue sky exemptions as well, or register if you can't find an exemption under the state law. You can't permit, you can't engage in general solicitation unless you've registered in a state, and you can solicit there, in the general solicitation there. Now, you know, it said you can unlimited number of accredited and non-accredited investors, but keep in mind, and I don't like when my clients have to go to the non-accredited investors. And when we say it's cheaper to focus on accredited investors, here's why. The SEC has said that even if you only have one non-accredited investor, you have to provide them with audited financial statements. And you're thinking, well, I'm a startup brewery. I have $0 in revenue. I have like no assets at this point, other than maybe my couple $1,000s of contribution I have. That's nothing. I'll just go, you know, you still have to provide you have to go through and pay a CPA firm to do audited financials to show that you have $0 in assets, $0 in revenue, and you know, zero balance sheet, all that. That's costly, even to do something like that. And so that's number one deterrent towards focusing on non-accredited investors. If you stick to accredited, you don't have to do that. You can, again, you put disclaimers in your offering document that any financial projections are just projections, and no guarantees and all that. And because they're deemed sophisticated, they're deemed to understand that. Okay, so it's very costly to try to raise money from non-accredited investors. In 504, if you go that route and take advantage of unlimited non-accredited investors, you still have to provide those financials. 505 is similar. It goes up to $5 million in any 12-month period. Now here, you can solicit to an unlimited number of accredited investors and up to 35 non-accredited investors or unaccredited investors. And again, no general solicitation. You have to provide the audited financials if you target non-accredited investors. So again, you're looking at an exemption that's primarily restricted to accredited investors. And then you get to Rule 506. The Rule 506 is the most common safe harbor because 504 was $1 million in a 12-month period. 505 was $5 million in a 12-month period. 506, unlimited amount of money you can raise through a 506 offering. So you can do $50 million if you wanted to. You are limited to accredited investors only. Oh, I'm sorry, no. Unlimited number of accredited investors and up to 35 non-accredited investors. But again, if you go non-accredited, you have to provide the required financial statements. So again, the 506 offering has historically been restricted to accredited investors only. And again, I can't stress it enough. Even if you sell just to one non-accredited investor, you have to provide to everyone those required financial statements. So if you're going to rely on one of these types of exemptions, stick to accredited investors. Now, talk about the Jobs Act. I say it's a game changer for startups, and not just breweries. It is a game changer across the board because, like I said, for the first time in 80 years, the federal government relaxed some of the securities regulations. It's been a little bit frustrating and humorous to watch this all play out. The Jobs Act, of course, was signed into law by President Obama on April 5th, 2012. Now, show of hands, anybody know what happened in November of 2012? Yeah, this was a great idea in terms of the House, the Senate, and the President to pass this law to make it easier as the economy was still, bouncing around on the bottom, to make it easier to raise money for a startup. The problem was the SEC hates it, and they have, they were supposed to put out regulations and all this stuff. I think it was originally January of 2013. I think they finally came out in 2014 with proposed regulations for the crowdfunding part of this, which were universally deemed as horrible. They came up with 581 pages, and I said they could have just saved the paper and just wrote on the first page, we don't want you doing this. I mean, you have to understand what the SEC, for 80 years, they've regulated the securities market. They see, there's a philosophy of it's their job to protect unsuspecting investors from, issuers that might be selling snake oil or something like that. So this idea that we're going to now liberalize this, the securities laws and allow everybody in cuts against the very reason why the SEC exists. And so that's why I think the commissioners have dragged their feet on how they're going to allow this stuff. So the three pieces of the Jobs Act that came out, that was passed in 2012, have been these two things. Relaxing the rules on general solicitation. There is a new, like I said before, we talked about 506. That was always considered, historically it's been called 506. Now what we used to know as 506 is now 506B. It's an unlimited offering to accredited investors and up to 35 non-accredited investors that doesn't involve general solicitation. 506C is the same parameters, unlimited amounts, unlimited accrediteds, 35 non-accrediteds, but now you can advertise it. You can use the internet. I'll talk about how you use that in a minute. Equity crowdfunding. The Jobs Act instructs the SEC to come up with rules to create an exemption or to permit equity crowdfunding. Okay? Now, to date, the SEC has not finalized their rules on equity crowdfunding. They have come up with this regulation 8+. I'll talk about that in a minute. But this is where the states got into the act because the SEC has been dragging its feet. And then finally, we get into regulation A+. And that's this new mini IPO or the test the waters type of thing where you can raise upwards of $20 million, $50 million. I'm not too concerned when I'm dealing with a brewery about regulation A+. I have some clients that are doing film financing deals. They're the ones that are probably going to take advantage of Reg A+. You don't need $50 million to start a brewery. So the ones that we're going to focus on here is 506C and crowdfunding. Okay. With 506C, it's very similar, but you're allowed to do general solicitation. So you can use social media, you can advertise. But what happens is a lot of broker dealers or financial advisors have set up portals that you can go through. I think there's one called Brewery, if I recall. That is one that's set up to solicit where it goes through accredited investors only through a 506C. Now the tricky part about 506C, when we do an offering document, we have a subscription agreement. And in that, I talked before about the accredited investor definition. In that document, when you give that to an investor, there's a set of representations in there where it says, the investor is an accredited investor by reason of the following. And you have all the possible the ways you can be deemed an accredited investor, and the investor, your buyer initials by the applicable exemption. Okay, so they're representing to you that they're accredited. Under 506B, you're allowed to rely on that. If you later find out that that isn't truthful, there's no ramifications for you as the issuer. That you were allowed to rely on their representation. Under 506C, it's you as the issuer that have to take reasonable steps to verify that the investors meet the accredited investor standard. That means getting tax returns from them, getting financial statements, getting statements from financial advisors that they are accredited. It's a lot more onerous for the issuer under 506C, even though the general solicitation has been relaxed. It's now the onus is on you, and if you don't do that step, if you miss something, and the person that you sold to isn't accredited, you just lost your exemption, and you just sold without registering. So that's not a good thing, because there are civil, administrative, and criminal penalties for selling securities in violation of the securities laws. There are some, now I talked to the folks at Brewery, and my understanding is that because they do the due diligence for the issuer. So if you go through a portal like Brewery, it's, I haven't seen the agreement, but I'm assuming there's some sort of indemnity or some sort of a contract between you and the operator of the portal that that covers you in the event that there's some kind of issue. But still, you don't want to do that. You're going to have to. It's a lot more onerous, in my opinion, to go through and do your own due diligence on whether or not somebody's accredited. So, but it's available. I haven't done one yet. All my offerings have been still the traditional 506B. You have accredited investors that you have someone in the group has a pre-existing relationship with, or a personal or business relationship, and those are the folks that I tell my clients focus there first. Again, it's cheaper. I mean, the cost to have me put together an offering document to give to an accredited investor under a 506B is probably about half that if it was non-accredited investors or a 506C or something like that. Regulation A+, I'll touch on here. This just was made effective last month. This is the mini IPO. This is Tier 1 and Tier 2 offerings. Tier 1, you can do up to $20 million in a 12-month period. You have to provide reviewed financial statements. Tier 2, $50 million in a 12-month period. You have to provide audited financial statements. You have to file annual, semi-annual, and current event reports. And some limitation of non-accredited investors can purchase no more than 10% of the greater of the investor's annual income or net worth. So there are some caps on what a non-accredited investor can purchase under A+. So what this is you said, you test the waters on an IPO. There's no shareholder limits. The typical 2,000 person, 500 non-accredited don't apply. They're unrestricted securities, freely transferable. You have to file all the filings via EDGAR, which is the SEC's online filing site. So again, I'm not too concerned about Regulation A+ for a brewery, but it's out there. It's brand new. This is the SEC's movement so far towards something resembling crowdfunding. Let's talk about crowdfunding, because I'm sure everybody wants to hear about it. Like I said before, the SEC has not finalized regulations on crowdfunding, and the ones that they propose nobody likes. So there is a provision under the Securities Act of '33 for an intrastate offering. And so when you talk about crowdfunding, what states have done is created an intrastate exemption so that you can solicit, and we'll talk about Minnesota's in particular. This is a little bit up, this is as of May of 2015. I don't know about all the other, the yellow states here indicate that there's an exemption in progress. I can't speak for the other ones in yellow, but I do know that Minnesota's was signed into law. So Minnesota is now in the green states as of last month when the governor signed the Minvest bill into law. So Minnesota has an equity crowdfunding provision. Wisconsin, Michigan, Illinois, Indiana, so you get some of those Midwestern states that all have some state, it's an intrastate exemption. What does that mean? That means that you can use this exemption to solicit prospective investors within the state where the issuer is located. You can't, in Minnesota, rely on the Minvest exemption and solicit investors in Texas, Oklahoma, Wisconsin, Illinois. You're limited, if you do it, to soliciting only folks in Minnesota. And you're limited as to how much you can raise, too. So you have, one thing, if you have to comply with there's Rule 147 restrictions in the Securities Act. You have to comply with those, which means, so here it is, the company must be incorporated in the state where it is offering the securities. It can only sell securities to individuals residing in that state. 80% of the company's consolidated gross revenues must be derived from the state in which the offering is conducted. 80% of the company's consolidated assets must be located within the state in which the offering is conducted. And 80% of the offering's net proceeds must be intended to be used and actually used in connection with the operation of a business or real property, the purchase of real property located in, or the rendering of services within the state in which the offering is conducted. You can raise up to $2 million with audited, reviewed financial statements, and up to $1 million with internally prepared financial statements. And you have to file notice with the state. There is also, under the Minvest law in Minnesota, there is this small corporate offering registration called SCORE, which also allows you to use, there's no restriction on the use of proceeds, assets, or revenues. You can use social media to do it. You can raise up to $1 million. You have to file a detailed offering memorandum, and you can seek a coordinated review to sell in multiple Midwest states. So if there's other states that have a similar exemption, you can coordinate a review and be allowed to sell that in multiple states. You have to go through a portal under the Minnesota crowdfunding law. In these portals, the operators of the portals have to register. So a broker-dealer can register them. Non-broker dealers can also operate a portal and register it. But the difference being what the portal operator can receive as payment for helping conduct the offering. If you're a registered broker-dealer that operates a portal, you can get your traditional commission. If you're a non-broker dealer, you can only get a flat fee. They don't. Again, this goes back to the securities laws, and non-broker dealers can't get commissions on the sale of securities. So you can only get a flat fee for, you can charge, say, $500 for use of the portal. You can't charge a commission. You have to run through an escrow agent. I think Minnesota's you have to go through have the funds escrowed through a bank that operates in Minnesota. Wisconsin's is a little bit more restrictive. I don't know if they've changed it since then, but there was some criticism because Wisconsin's crowdfunding law required that the funds be escrowed at a bank that was chartered by the state in the state of Wisconsin. So they excluded federally chartered banks, and I know there was some criticism of that for some time, and that's part of why Wisconsin's crowdfunding law wasn't used heavily right away. I don't know if they've changed that since then, but that was one of the criticisms of Wisconsin. Like I said, every state's going to be different. This goes back to the blue sky laws. That's what these equity crowdfunding exemptions are. It's just another exemption thrown into the state blue sky laws that you can rely on, because up until the reason that we're talking why we have to have the funding exemptions is because most states' law, I mentioned about under the Reg D, these restrictions on no more than 35 non-accredited investors. Most states have a limited offering exemption that mimics that language. So under most, if you go unless you have a state crowdfunding exemption, an intrastate exemption that allows unlimited number of investors, if you raise money through 36 non-accredited investors, and you didn't register with the state beforehand, you violated state securities law. You were capped at 35 non-accredited investors before these crowdfunding exemptions. So that's what these are. It's another tool in the toolbox you can go through. When we do an offering, we go through and figure out each state. Okay, we're soliciting. Let's go through grab the state statutes, and we find that exemption, and then we go figure out what has to be filed before or after the sale, and how soon before or after the sale, in order to meet that safe harbor. So this is just another one of those tools in our toolbox that we use. Okay, so is everybody still awake now that I've gone through all the federal and state securities laws? So for the last 10 minutes or so, let's talk about some practical stuff. Okay, you hire me to go deal with all that garbage, right? You want to know, okay, now I'm out there, I want to raise money. How much do I have to give away? What do I have to offer to get somebody to invest in my brewery? What percentage of ownership to sell? You don't want to obviously go over 51%. If you have to, you know, if you're needing to raise a lot of money from investors, you know, and don't have a lot to put in yourself, you may have to give more, but you can always do what I call, you know, a buyback provision. So you can, you know, or a buy down provision. So you put in the documents at the outset that, you know, maybe the investor owns. I haven't had to do one yet where I had to give more than 51% away. Typically, I'm doing, you know, 30, 40% tops to investors. See, but you may have a provision where after, say, 5 years, the company has the right to buy back a portion of the shares issued or buy all of the shares issued. The idea being that eventually these guys are going to get it up and running, and then you want, you know, once you get cash flow, you want to bring you know, get it back down so that the original founders of the brewery can make some money off of this thing, considering you put your lives on the line and sacrifice and pledged everything in the world to start this brewery, right? So that's one of the big issues. What percentage of ownership to sell? Like I said, it depends on how much you're trying to raise. That's why I say, if you go back to the earlier discussion, that's why you go talk to the bank first. That's why you go figure out if there's any gap financing available. That's why you whittle that number down to the smallest possible, because the smaller the number is, the less you have to sell to somebody else. Also keep in mind, especially with an LLC, which most of these are done as LLCs, because there are no restrictions as to who can own an LLC. If someone wants to come in and invest through a trust, through another entity, their corporation, their LLC, they can do that by investing in an LLC. With an S corporation, which is also a pass-through entity, there are restrictions as to who can be a shareholder in that type. So I would say 90% of my brewery clients, and 100% I think of the ones that are have had to raise money through investors, are LLCs. And with an LLC, there's a difference between voting rights and financial rights, or governance rights and financial rights. An investor may not care about having, you know, the right to control the entity through voting. They may only care about what kind of money am I getting out of this. They may look at this as a passive investment. They may even, believe it or not, look at it as they want. I've had some deals where the investor deal is that they want the losses allocated to them 100% in the first couple of years, because they've got some other income that they're trying to, you know, shelter. And so, you know, for the first couple of years, while there's losses in the brewery, the tax losses, they want them. You know, so that's, you know, we got to do a few deals like that. So what I've had to do, I've had one where I've had to raise a lot of money. What I try to, you can vary the distribution. Like, for example, let's say that you're going to sell 30% of the ownership to outside investors, and you're raising, say, $1 million from them. Okay, that's a little bit more money to ask for 30% than is typical. So what you could offer is say, okay, until you've received enough distributions to recover what you've put in, you're going to get 70% of the distributions to your group, the 30% group, and the founders are going to share 30% of the distribution, because theoretically the founders are going to be drawing a salary from the brewery as well for working in it. Okay, so you can do something like that. You can offer a preferred distribution. A lot of times we'll call it, it's called a cumulative preferred distribution. It's like an annual interest payment. It's like so you can, you know, distributions sometimes may vary depending on whether or not the company has the funds available to make the distribution. But you can guarantee saying, we're going to give you at least a 6% cumulative preferred distribution. Meaning, if we don't have the money in year one, it aggregates, accumulates, and goes to year two. So we'll, you know, so you'll get something in year two. So you're guaranteed to get it. So it won't be more. We won't build up more than 2 of these payments, and then we'll have to make 1 of them. So it's a guaranteed payment. It's like an interest payment. And like I said, you want to have something in there like sunset provisions. Call rights are where the company has the right to call the shares for a price. You can put that right into your buy-sell agreement, and you want to get that agreement in place before you hit the street with your offering, because you want to say these are the terms, right? And you disclose all those terms. And my little piece of practical advice: always beware of what you can get your offering all put together. Here's the doc. We got our LLC documents together. Here's the offering. Here's the terms. and you go out in the streets, and someone says, well, what about this idea? Okay? Everybody, I can't tell you how many times I've had a client that some investor comes to them with changes to the offering. If you have raised money already, you can't go changing the term through that offering. You can't go changing the terms of the offering to get investor number 4 in, okay? If you change the terms of the offering, you then have to go back, disclose the material changes to all the other people that have put money in, and give them the right to rescind, okay? So what I always tell clients is, if you've got somebody coming to you with that wants to change the offering, tell them to get the checkbook out and take the whole offering. And then we'll just give back the checks to everybody else. We'll just rip up the offering document, close the offering, and do a one-off deal just with that investor. But no, we don't change midstream. We don't start changing. We don't have 3 offerings within the one offering to get there. And it's hard. It's very, clients are like, okay, I want to get going. I want to go brew beer. I want to do this. And so sometimes I have to talk them off the ledge. And so far, every one of them has worked. And so you have those days where you get a little nervous, but it works out. And be aware of, I don't want to call it necessarily scams, but investors that have some ulterior motive other than, being part of, a passive investor in your brewery. It's like, you don't want to have I've had some where, well, yeah, I will invest, but I don't want you to lease that building. Come lease my building. Because there's usually, they need a renter in there to refinance or something like that. Okay, so you got to just be aware of one of my partners always says the advice when we're talking about raising money, he's been doing this for years, and he says, you have to trust who you're getting into business with. These people are going to be your partners. So you have to trust who you're dealing with, and if it doesn't pass the smell test, walk away. I mean, there are enough people out there that want to own these breweries. You'll find your investors. Yeah, you got a question?
Yeah, so another one that I see a lot is equity for services rendered from service providers. Thoughts?
I've had that come up a couple times where, oh, so-and-so is going to provide this in exchange. If it's part of the offering, you can't let somebody in on the offering with different terms than what everybody else is buying at. So what I've told clients is, whatever the amount that they're going to contribute in services, I have no problem with you cutting a check. They have to invest that in cash, and then they can perform the services, and then you can pay them for the services. But you can't just say, I'm going to give you services in exchange. If the offering is $1 per unit, you can't say, I'm going to offer you $1 of services for every unit. No, it's cash. So there's ways to deal with it, to work around it, but you can't just say, yeah, I'm going to take services from this person. Because at the end of the day, practically speaking, the reason you're doing the offering is because the bank has told you they'll lend if they have X amount of cash, right? Well, you have to have cash. So you can't, the services are nice, that you're going to be able to cut that off your budget, but you still need to have the cash to show the bank that you have the equity to be able to close the loan. So practically speaking, it doesn't work too. Other questions? Okay. Well, you've got a packet of stuff there. There's a lot of different articles on various things related to breweries, including we've got the slides in there, and then I did put in there for anybody that really wants to brutalize themselves, I did put the text of the Minvest bill in the packet so you can see what it looks like in practice. You have my card in there. If anybody has any questions, I'm happy to answer them. I'll stick around a little bit here. If anybody wants to add any specific question, want to come and ask me. But I appreciate you guys all attending. I appreciate you guys all staying awake for this. And have a good rest of the day.